Well, hello, this is Janet Marana, Executive Director of Priest for Life. Welcome to our program. And of course, as always, I'm joined with Father Frank Pavone, our National Director. And this is class number 5, right, Father, on the Dobbs decision, digging deeper, diving deeper. Because, brothers and sisters, there's a lot of misunderstanding out there. Of course, the other side is really exaggerating things, and one question you can say to anybody who is claiming things, just say to them, have you read the decision? Right, Father Frank? And very few
Yeah.
people will even say, oh, yeah, I read the decision. So we are going to go into the 5th part tonight. And of course, we will take your questions. So if you have questions, start thinking about them. But Father, why don't you begin as to what point we are right now in delving into this decision?
Well, we reviewed yesterday a stare decisis, this idea that the court should stick with decisions it has already made. And we reviewed that, yes, there are important reasons for that. But then we reviewed the 5 reasons why the court decided that in this case, the rules of stare decisis require that indeed Roe and Casey be overruled. So we reviewed that. After that section of the decision, it goes into another argument that Planned Parenthood versus Casey made, and that the pro-abortion side in this case repeated. As a matter of fact, Janet, the only defense that they had, the pro-abortion side in this case, was to simply keep repeating what Casey already said. They didn't come up with anything new. So this particular argument goes something like this. Well, this is a very, very politically contentious issue. Well, of course, with that, we agree, right?
Right.
No other issue divides the American public as bitterly and intensely as this. No other matter is felt so deeply and personally by so many tens of millions of Americans on this question. But the argument goes like this. Because it is so politically charged, because it is so divisive and unsettled, the court should not overrule its precedent here, lest it be seen as subject to politics and the winds and waves of public pressure. Now, you might recall from one of our past programs that I mentioned that the judgment in Casey, if you read the Casey decision, the justices left open the idea that, well, maybe they weren't even convinced that Roe v. Wade, which they were technically reaffirming, although they were changing a lot of it, was decided correctly in the first place. However, even though, and I mean, we know that 4 of the justices in that case were ready to overrule Roe at that time in 1992. But the others, the plurality as it's called, said, well, we might not all think that it was such a great decision, but if we reverse ourselves now, we would undermine the credibility of the court. And thus did they undermine the credibility of the court by saying we're going to stick with a wrong decision, just because it's been around so long and it's so politically charged. And the majority in the Dobbs opinion responded to that argument, Janet, in a way I think we would all respond to it by saying, what is the duty of the Supreme Court in this matter? What is the job of the justice? Is it the job of the justices to take account of things like this? How we're going to be perceived? How hotly the issue is debated in the public? Is that what they're supposed to be focused on? Or are they supposed to be focused on the Constitution as it's written and the laws as they are written? And that's where they came down. They said in this Dobbs case, listen, if this was wrongly decided, and we believe that it was,
Right.
well, then it doesn't matter how much time has gone by, and it doesn't matter how much public controversy there is, we're going to correct our mistake.
Right.
Now,
So Father, when I think back now to Plessy versus Ferguson and Brown versus Board of Ed, it's kind of the same thing.
it
But
is.
if you think back to the 50s, we had segregation in our country. And in the South, it was real hardcore segregation. They had
Right.
signs up, blacks use this water fountain, whites use this one, lunch counter, whites go here, blacks go there. It was hardcore, and the nation was divided about that issue, just like we are today about abortion. So
Yes.
it's kind of like, wouldn't you say, Father, it's the same thing? Like, well, when you think about it, when Brown versus Board of Ed said, no more segregation, it took well into the mid 60s or more, right? When we had the Civil Rights Act came about, other things to kind of, and see, that's the point. Brown versus Board of Ed kind of did what Dobbs did. It threw it back to the legislature saying, no, you can't segregate, but it kind of left it to the legislative body, to Congress to legislate. And how many years did it take later till they finally legislated? And we had like the Civil Rights Act. We're kind of, wouldn't you say, Father, in the same situation right now, right?
Yeah, I think so. And they refer to Plessy. They refer to a lot of cases where they've corrected previous errors.
Right.
That one is probably the most gets the most attention, is the most egregious error, the most well known. I want to refer here to another set of cases, the Lochner cases, Lochner v. New York, and a number of other cases came in its wake. And the similarity that they have to the Dobbs case is this. In New York, there was a worker who was working beyond the maximum number of work hours per week that the state of New York permitted. And just like the so-called right to choose abortion is proclaimed by some as residing under the liberty clause of the 14th Amendment, the due process, substantive due process, like we talked about the other night. So in that time, they were saying, well, there's a right of contract. The employer and the employee, if they enter into a contract, and so what if it's more than the maximum number of hours that the state law allows? We have this right. And the Lochner case actually agreed with that. So there was an undermining of the law, and there, in the name of a right that was nowhere in the Constitution, but that they were claiming derived from the liberty of the 14th Amendment. Then there were a number of other cases that reinforced this, until finally there was a case called West Coast Hotel. And that had to do with minimum wages. Again, it was a company and an employer, and she was getting less than the minimum wage required by California law. Well, finally, at that point, the Supreme Court started looking at this string of cases and said, wait a second, we've got to be very careful about people claiming that there are rights that you don't see in the Constitution, that are deriving from this substantive due process, as it's called, from the 14th Amendment. And they overruled it. They overruled it in the West Coast Hotel case. So Dobbs refers to those cases and says, look, we're not doing anything novel here. And the other side, today Biden was meeting with some Democrat governors, and he was complaining again that, this decision is taking away people's rights. There were some international comments made by some leaders of other countries and leaders at the United Nations. Oh, you're depriving Americans of their rights. They were doing no such thing, and they're not doing anything unusual here. This is a step the court has had to take before. Plessy versus Ferguson, reversed by Brown versus Board of Education. Lochner versus New York, reversed by West Coast Hotel. So, Janet, it's yeah. So these justices are saying, look, we don't go according to the public dispute that's going on. We have to go according to the Constitution.
Right. Okay, so Father, tonight's class, we're going to focus on the final points, aren't we?
Yes. Now, there's a couple of very interesting additional points and very big questions. Let me continue on this question of public opinion, because there is a quote that, in the light of the leak, of course, they wrote these words before the leak, so they didn't know that was going to happen. In the light of the protests and the intimidation and the threats, listen to this paragraph from the end, towards the end of this decision. We do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We hold, therefore, that the Constitution does not confer a right to abortion. Isn't this refreshing language? I mean, here they are, and you can see in these words right here why these justices, and I was telling people all along, as you were too, during from between the time of the leak and the issuance of the decision, which was almost, we went through all of May and most of June under that situation. And, many people were saying, oh, are the justices going to waver? Or is anyone going to change their opinion? And we said no, right? Because, and these words,
the point really is, Father, this is the thing that they swear to when they're sworn in.
Yes.
Every judge, the president, members of Congress, everybody, even Nancy Pelosi and Chuck Schumer. They take a pledge to uphold and defend the Constitution of the United States as it's written, not how you want to morph it or how you want to interpret it. No, as it is written. So you can't kind of read a sentence and go, well, in that sentence, I think I can twist it around and somehow think this is what it is. No, you took a pledge to uphold it as it's written. That's the problem we're having right now in our country.
Yeah.
And to be honest, Father Frank, I mean, I don't know how much you've been listening to the news. You need like a tough stomach. But these Democrats, they're calling for we should just dissolve the Supreme Court. Excuse me? Can't do that. We have 3 branches of government: judicial, legislative, and executive. You just can't will away a branch of government. It's embedded.
The Supreme Court is established by Article 3 of the Constitution.
Right, exactly. Yeah. But this is the ridiculousness they're going to, Father. It's like they want to ignore the Constitution and just kind of tweak it to what they want it to do. And the statements that they're making right now, it just sounds, let's impeach the Supreme Court. You can't impeach the Supreme Court. It's like, I really want to take, I know I have a copy too, but I think it's in my briefcase. We all have a copy of the Constitution and the Bill of Rights. I think we have to wave it at them and say, guys, I think you need to read the document.
Reread it. Look, it's not very, it's not very long. Here it is right here. It's, so
it's an easy read.
No, it is. And an important one. Right. So let's go into one final
argument,
an important conclusion at the end of this decision. I'm going to go to the board to the whiteboard to explain this one.
See, I told you guys he was going to get to that whiteboard. He loves it. He can't.
Janet,
if he were to tie his hands behind his back, he would be speechless without his whiteboard.
Here's an important question that the Dobbs case answers. Okay. How will the court or the courts decide whether a pro-life law, so whether it's passed by a state or by Congress, because Congress still has its role here, but how will a court now decide whether a pro-life law is constitutional? Because if it's not constitutional, it would have to be struck down. It would have to be blocked in its enforcement. A court can't wipe a law off the books. That's the legislature alone can do that. That's Article 1 of the Constitution. But the court can say it doesn't correspond to the Constitution, and therefore you should not enforce it. All right. But how? So another way of putting this question, and attorneys and law students will understand or be familiar with this language, what is the standard of review. Okay, so we understand the question, right? Okay, when Roe versus Wade was decided, the standard of review was strict scrutiny, as it's called. In other words, the highest and hardest bar that you have to reach for a law to survive in court. Is the state going to succeed in defending the law that it just passed when it gets challenged in court? Well, the standard of review basically is a measure of how hard or how easy is it going to be for the state to win in court and defend its law. Under Roe, it started off in this very, very high category. Okay, now strict scrutiny only is applied when you're talking about fundamental rights. Now, unfortunately, we've got a lot of people in this country who think that abortion is a fundamental right. This is what the Democrat Party is saying.
Right.
And this is like, Janet, it's like freedom of speech, freedom of religion. You know, can the government restrict those? Yeah, but like this, okay, only in a very, very, very narrow circumstances. Our freedom of religion, you know, Janet, because we went all the way up to the Supreme Court. In our case, our freedom of religion was being restricted when the Obama administration told us we had to provide coverage in our health insurance for contraceptives and some forms of abortion. And the argument we made in court was precisely what this strict scrutiny is all about, namely that the government can restrict the fundamental right only if there's a compelling state interest. In other words, something that's really, really of the highest importance for the state to do. And in pursuing that compelling interest, it's using the least restrictive means possible. So that's the language, okay, that constitutional attorneys and the courts use to talk about this particular standard. Then you have Casey came along. Remember I said that Casey changed a lot of what Roe said, right? They sort of upheld it, but sort of like at a distance. They said, well, we're going to uphold it, but we really don't like it. And we're going to change this, and we're going to change that. We're going to replace this with that. Okay, so one of the things they did was they changed the standard of review. And instead of strict scrutiny, it was an intermediate form of scrutiny called, actually, it was something that was it never existed before. They just made it up, okay, namely undue burden. And we talked about this in a previous lesson, okay? In other words, a state cannot
undue burden is another just vague thing.
Yes, exactly. And that's one of the reasons Dobbs reversed Casey, because they say it's too vague. It's remember, one of the 5 reasons that they overruled unworkability, right? Unworkability. You give the courts a standard, right? Remember, because the Supreme Court, when they issue these standards of review, they're imposing them on all the other courts of the country. All the other judges, hundreds and hundreds of federal judges across the country, have to adhere to these standards, and they were all interpreting them different ways. Even the justices on the Supreme Court was interpreting it different ways, because undue burden does not define itself. Okay, that's a form of intermediate scrutiny. Okay, what did Dobbs do? Here's the beautiful thing about Dobbs, because we were hoping for this, and it's what they did. And the state of Mississippi was arguing for this. And those of us that submitted friend of the court briefs were arguing for this. And this is what they did. Let me just make some more room here at the top. They put abortion back down with the rest of the world, so to speak. The rest of issues, all the other issues that the courts decide on, for the most part, Janet and friends, for the most part, they use what is called rational basis review. And look, friends, this is really very much like it sounds. Janet, what it says is that if a state passes a law, let's say we're going to pass a law like the heartbeat bill, right? Protecting the babies from the time a heartbeat is heard, any kind of pro-life law, anything you want, right? If it gets challenged in court, rational basis review asks 2 questions. Number one, is the state pursuing a legitimate interest. Okay? Legitimate interest. Notice it doesn't say compelling interest, like with strict scrutiny. Just a legitimate interest. Now Dobbs actually gives some examples of legitimate interest, and protecting the baby in the womb is one of them. You're protecting human life. Of course, that's a legitimate interest. Is the state pursuing a legitimate interest? Rational basis review. Number 2, are they doing so reasonably? In other words, when you look at what they're doing with a particular law, does it stand to reason that that law is advancing that interest? So you say you can't perform an abortion because we're trying to protect the baby's life. Yeah, that's reasonable. Now, that doesn't mean that the court that reviews this law has to agree with it. They don't have to agree with it. As a matter of fact, let me go to a particular quote here from the decision itself. Okay, because they, when they write these decisions, when they write these opinions, they are quoting all the time from other Supreme Court cases that establish certain doctrines, certain guidelines, and one of them is these words here, this phrase here, that the courts, when a state law is brought before the court, okay, because somebody that doesn't like it is challenging it, there has to be on the part of the court, and Janet, this is where, when we talk about power being given back to the people now to stop abortion and to protect the unborn, okay, strong presumption of validity. So in other words, strong presumption of validity. That's what the court has to have when they look at the state law. So in other words, the court is not supposed to second guess the lawmakers. They're not supposed to say, we know better than you do. Yeah, but wait a minute. Janet, who's closer to the people? The 9 justices in Washington, D.C., or the legislators there in Mississippi or Louisiana or any
legislators?
The legislators are closer to the people.
Mm-hmm.
Who has more time to listen to the experts give testimony? There's 9 justices on the Supreme Court or the legislatures in the states?
Legislators.
Right? They have more time to hold hearings. They can have witnesses. They can have amendments. A bill is introduced. A lawmaker stands up. I have amendments. Who has more time to listen to more people? The legislators in the states or the 9 justices in Washington, D.C.?
States.
And how do they listen to the people?
They have hearings.
They have hearings, but also even before and after the hearings, the people can come in and sit down with their state legislators.
Oh yeah, visiting, yeah.
And visit
I mean,
with
when
them.
you think about it, Father, the Supreme Court only hears the arguments on one morning. I mean, Dobbs was heard
for 1 hour.
For 1 hour.
Yeah.
Right? Dobbs was heard, the testimonies on both sides on December 1st, for what was it, 1 hour?
Well, they went a little longer, and often they go a little longer, but
an hour and a half.
A couple hours, right.
No more than 2 or 3 hours, max.
By the way, Janet, somebody's asking, does Father Frank have a puppy? You want to answer that question?
Oh, sure. No, Janet has 3 Shih Tzus. I'm enjoying this broadcast from my home. They're inside in my living room, and we're getting like a chance of a little thunderstorm. And when there's any thunder in the distance, they feel compelled to bark at the thunder.
Yeah.
That's what's going on.
I'm going to ask our technician when I'm talking, just mute Janet, because the doggies are getting a little too loud.
They're rambunctious. And the door is closed. They're in.
Even before they close. Okay, so let's get back to the point. So the court is saying, look, you have to give a strong presumption of validity to anything that the state legislators pass. And here is another very encouraging guideline of the court, that the court cannot, okay, the court cannot, and let me put the exact words here, substitute their social and economic beliefs for the judgment of legislative bodies. Substitute their social, that is the justices, okay, their social and economic beliefs. Certainly they have such beliefs, but they have no place in the court judgment. They're not to substitute their social and economic beliefs for the judgment of legislative bodies. For brothers and sisters, do you see how these holdings of Dobbs are giving you more power? They're giving more power to the people because we, the people, elect and lobby and, if necessary, vote out of office our lawmakers. We can sit with them. We can reason with them. We can testify before them. The court is not going to get in the way of that. They're not supposed to substitute their judgment for the judgment of the people that we elect, who work for us, who are accountable to us. And they are supposed to give, when the legislature, like when Mississippi says, hey, we're going to protect babies from 15 weeks, here's where we're drawing the line, 15 weeks forward, that is to be given a strong presumption of validity. The court's not supposed to second guess. So, Janet, this is a very, very important thing. I'm going to put one more thing on the board before I sit back down. And that is when it talks about, again, rational basis review, it's the lowest, most common method of the court reviewing a law that gets challenged, okay? And when we say the state is pursuing a legitimate interest, what are some examples of legitimate interests, especially in the abortion context? Well, Dobbs actually, concluding their opinion, gives a few examples. And I want to show you what those examples are, and then Janet will sit down and we'll talk a little bit more about this. Let me get the specific examples that I want to quote to you. It's from page 78 of the decision. Among these examples, these legitimate interests include, and we're going to like these, pro-life people are going to like these, respect for and preservation of prenatal life at all stages. So, Janet, the door is open here for laws that protect babies from conception, okay? To protect prenatal life at all stages, protect and respect, is a legitimate state interest. The court is now explicitly saying, this was true already, but they're explicitly hammering this out. Secondly, the protection of the health and safety of the mother. And you and I know, Janet, how abortion harms women, and the Silent No More campaign and Rachel's Vineyard and all the healing work that we do shows this beyond the shadow of a doubt. Thirdly, to eliminate barbaric and gruesome procedures. Okay, so protect the integrity of the medical profession, so you don't have doctors, being paid to, dismember babies or take their skulls apart piece by piece. They're
Well, and
gruesome.
of course, by the late term abortion too. I mean, that's like
That's
so
right.
barbaric.
That's right. Or limit barbaric procedures and preserve integrity of the medical profession. So, in other words, any state laws profession can advance these interests. And then they also mention to mitigate fetal pain. To mitigate fetal pain, so you have, and this, of course, brings to our mind some very specific laws that have been passed in various states. Congress has not yet been able to pass this, but various laws in states say we're not going to permit abortion once the point is reached that the baby feels pain. And that, by the way, was part of the argument of Mississippi, too, for the 15-week ban. Okay. And finally, they mention discrimination on the basis of sex or disability. And some of the laws, some of the pro-life laws in the states have been based on this. In other words, you can't do sex selection abortion. You can't do abortions because it's a black baby, or disability. Disability. The baby has
Spina
Down syndrome,
bifida. Spina
right? Spina
bifida.
bifida or some other condition. Oh, well, therefore, if I do a prenatal test and I find out the baby has a condition and I don't want to deal with that, now, I kill the baby. And some states have said, we're not going to permit abortions for those reasons. So the court is coming down on the side of freedom here and saying, look, these are legitimate interests of the state. And we're not going to say to those states, you can't do this. So, Janet, the door, in other words, I'm going to sit back down here. The door is wide, wide open now for all kinds of pro-life legislation. And this is really a beautiful thing.
Yeah, it is. And by the way, here's the barking culprit. This is
look at him.
Alfredo. He's here to apologize. Sorry. But Father, some people now are asking, I don't know if you have the questions over there, but I've had people asking that already, as you know, we've been sending out press releases in certain states. They now have certain federal judges trying to create injunctions to stop the states that have trigger laws and other things going into effect. Like here in Florida, there's a federal judge here who said, oh yeah, I'm going to stop Florida's 15-week ban from going into effect. And of course, Governor Ron DeSantis has already said, well, we'll just go back to court with you. So what do you see as what's going to happen here now? Are we going to, in other words, because the Supreme Court has done what they've done, how can a federal judge try to undo that? Or is this part of the gymnastics or circus they're going to try and go through, but we're going to win in the end? I think that's what people want to know.
It's going to be gymnastics for a while, but I believe that the kinds of, well, first of all, federal judges, again, they are bound to apply now the Dobbs decision. Now the Dobbs decision is precedent now. Okay, so it enjoys the force of precedent. It enjoys the rules of stare decisis itself. So that
so they basically then, even though they're trying to do these injunctions, they can't ignore Dobbs.
Well. Here's the difference. Now, what's happening is that some of these laws are being challenged in state court for how they correspond or don't correspond, not to the federal constitution, but to the state constitution. So, as I've been saying over these last months, the battle now, when we say the battle goes to the states, of course, the battle has already been in the states, but now it'll intensify as the states are given more leeway by the courts. But part of the battle in the states is not just in the legislatures, it's in the state courts, and it has to do with the state constitution. But Janet, even though these documents are different, obviously the state constitution is a different document in each state, and it's different from the federal. However, there are legal principles, many of which we've been teaching in these sessions. And I think that the arguments made in the Dobbs case are going to have an effect even on these state judges. Let's give one example of a principle we've been talking about a lot in these classes, which is that you can't argue from other cases that deal with privacy rights. You can't argue from privacy rights that deal, for example, with whom you're going to marry or how you're going to educate your children, and questions like that, to a right to abortion, because the thing that makes abortion unique is there's a second life involved. Whatever you want to call that life, whatever value you want to give it, there's a second life, and abortion purposefully ends that life. And so it's in a category all its own. Regular laws of privacy don't apply to that. So, Janet, that argument, it seems to me, is just as powerful on a state level as it is on the federal level, right?
Right. Yeah. So, what I've been telling people is just be patient. This is the left trying to, reel its ugly head to try to still get their way. But in the end, they won't be able to, because, like we said, I think just about most state constitutions, just like the federal constitution, there's no right to abortion in these constitutions, right?
No. Well, some of them have. Some of them have. Some of them have right to abortion, but that can be changed, and it's going to have to be changed. And that's one of the things where we can change it. Some of them want to put the right to abortion in their constitution. And this is where the battle is going to be. The power we have to be. It's like I was saying, even in places like California and New York, in talks I've been giving, interviews I've been doing. Even in those places, people can change things. No state is permanently blue or permanently red. In the red states, we have to be constantly vigilant. In the blue states, we have to be constantly fighting against the status quo and changing it.
Right. Which, of course, brings us to the midterm elections in November.
Yep.
And it's not just the federal, the House and the Senate, which is very important. And that's what we have to make sure we put the pro-life people in, but in your state legislatures and also in who's running for your local judges, because that also affects the whole thing, right, Father?
Yeah,
so
that's right.
You really, really have to be very diligent. And for those who might be wondering, well, how do we check it all out? Join our prolifevote.com. Go there, join our election team, because that's what we're doing. We're educating everyone how to inform voters, how to register people, because we're going to be in for a real big battle here, and we've got to win big in November. And I think
very big.
Educating everybody, I think we can do it.
We have nice comments coming in. Charity 2019 is saying receiving this detail is very helpful. We want to give you all these details and all this information. So thank you for saying that. Let's see if there's other questions or things that people want to emphasize or ask. Well, Michael is talking about some governments trying to push for children to be euthanized. Yeah, it's part of that whole culture of death, isn't it? It's just part of this whole lust. It's a lust for death, and it's a lust for power and control. Because some of these governments, they think they can control, whether it's the way their economy goes or other things they're trying to accomplish by taking human life. And these are obviously things that need to be resisted at every stage. So, Janet, this is great. So we've gone through the main arguments of the Dobbs case, and I want to read how it finishes, because this beautifully sums it all up. The last paragraph. Oh, by the way, the appendix of the Dobbs case is a listing of all the state laws that were in effect at the time the 14th Amendment was adopted, state laws banning abortion throughout pregnancy. But listen how this decision ends. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. If that isn't an American statement, if that isn't a reason to celebrate our independence this weekend, I don't know what is.
I know. It's beautiful, Father. Well, I want to remind everyone that you can go to SupremeCourtVictory.com. That's where all 5 of these programs are posted. So you can re-watch them, and you can encourage others to do the same, because I think there's still a lot of confusion out there. We are going to rerun them next week in the same time slot, Monday through Friday, just because we want to keep reaching out through social media and keep getting a big audience of people to get informed. It's so important. We've got to cut through all the misunderstanding out there so that people can really understand these beautiful decisions that we're just celebrating as, wow, what a victory. What a victory. So I guess if there's no more questions, Father, I think we've.
Well, Jenny, you might want to. We could answer this together. Walter is asking, how do we get our Catholic friends to speak out? That's always the challenge, isn't it? And that's always the goal. How do we get them to speak out?
Well, you know what is, I always tell everyone, start within your own circle of influence. Start with the people. Now, if you have pro-abortion friends, don't try to convince them, but start with your pro-life friends and start educating them on the decision. Tell them about SupremeCourtVictory.com. Encourage them to listen to this 5-part series, because once they see how beautiful this decision has been written, it will give them the courage to speak out, because they'll see this is great. This wasn't just kind of, oh, let's just overturn Roe v. Wade. Very logical thinking, step by step, like Father has helped us understand this week. So I think step one is we got to educate them. And once they're educated, then we can get them to speak out. Would you agree, Father?
Giving them an insight, giving them because remember, think of it this way: people are not going to speak out unless they're confident first. Well, of course, a lot of people violate this rule, but I'm saying you want to get people to speak out. The more confidence you give them in what they understand and know, and that they're going to be able to articulate it when they speak out, and they're going to be able to defend themselves against somebody who might object, the more they're going to speak out. We got to increase their confidence. We increase their confidence by increasing their understanding. We increase their understanding by, well, doing things like we're doing tonight. Hopefully a lot of Catholic people that are watching this, and not just Catholics, but everybody, will, after they understand some of these basic points, they'll be able to speak out better. Janet, maybe around the dinner table on 4th of July, when one of their
at those barbecues.
When one of their friends says, "Oh, isn't this terrible? The Supreme Court took away abortion." I said, well, wait a second. Did that what we just heard? They didn't take away abortion. They left the decision to the people.
That's right. But, so maybe there's going to be a lot of fireworks at these barbecues, Father, in these discussions. Yeah. So could you, Father, close us with a prayer?
Let's pray. Father, we thank you for the Dobbs decision. And we thank you for giving us an opportunity to study it, to explain it, to talk about it. And then now, Lord, to go forward and speak to others in a way that they will understand it. Bless our nation, bless the legislators, bless the voters, bless the people, bless everyone. Bless America, because we have turned a corner. We thank you, Lord, for this brand new opportunity. May we make use of it, and may it lead to us to a culture of life. We pray through Christ our Lord. Amen. Janet, I was saying today that, it's been a week now, a week ago today, that we heard this decision.
That's right.
And we haven't stopped rejoicing since. We haven't stopped smiling since. And you know what the reason is? I thought of it this way. For me, Roe v. Wade came down, I was 13 years old. I haven't had a day until this past week. I haven't had a day since I was 13 years old of living in this country when human beings could be protected throughout their entire lives, from beginning to end. Because for all these 50 years, thanks to Roe and Casey, the government was saying, no, they cannot be protected from conception to viability. Can't be protected. Cannot be.
Right.
And now, for the first time, human beings can be protected in America for the entirety of their lifespan. That's a profound thing.
It is, Father. And I know we always thought that this would happen in our lifetime. We always thought it would happen, but I just didn't think it would come out of the blue just like this did. So I'm grateful for it. We still have so much work to do, but at least it's given us like new footing.
Oh, it has new footing. That's a good way to put it. Yeah,
new footing in the battle.
Yep.
And when you think about it, Father, can you think of how many years we used to say, can we just get people to discuss abortion? Can we get them to talk about it? Now they're talking about it.
All over the place.
All over the place, And that brings me to the final point where we say goodnight, is my book, Everything You Need to Know About Abortion for Teens. I want to remind everybody, now this is a good tool to help you talk about it. You can go to abortionandteens.com. and order a copy, I'll personally autograph it for you. And Father, some people have been asking, can we get a discount if we want to order in quantity? Yes, we can. So just contact our office and talk to our resource department, because if you want to order them like for your youth group at your parish, or if you're homeschooling, your homeschooling group. And I'm also offering, once a group has ordered them, for the whole group and they've read the book, I'm going to do a complimentary Zoom meeting with the group for free, where they can meet the author and ask me questions after they've read the book. So I think that's a unique opportunity, Father, isn't it? So the whole purpose of all this is to educate, because if we educate everybody, they will be good, informed voters. And so abortionandteens.com. And by the way, anyone who knows a kid who graduated high school, it's time to get them registered to vote. As long as they turn 18 before November, they can be registered now. So there's another to-do item for you, brothers and sisters. Okay? Thank you. And Father, I guess it's about to say, God bless you all, and keep tuning in to our endabortion.tv, where Father and I both have continuous program throughout the week. God bless.
Bless you all.